Dennis from the Association of Supervised Ankle Monitoring Providers. Ms. Dennis, you want to come on up? While Ms. Dennis is coming up, I'll read the green cards in support, not wishing to speak. Liz Mangum with Lyft. Bradley Burkett, District Attorney for the 7th JDC. Chico Yancey with Vote. Mary Susie Labrie. Ronald Marshall with Vote. And Ivy Mathis. Ms. Dennis, good morning.
By the way, my card was a green card in support.
Yes.
Sorry.
That's why you're up.
Yeah, Jill Dennis with the Association of Supervised Ankle Monitoring Providers, with over 20 years' experience in both pretrial and post-conviction supervision. I am here today in support of HB 161 and to respectively ask that it be strengthened by an amendment. Under Louisiana law, courts at their discretion already have the authority to impose no contact orders, stay-away orders, and electronic monitoring as a condition of release. When victim protection is used correctly, it's not just a protection order. It is about real protection for the victim. It's a two-part system. First, when the court determines, based on the history and the charge of a defendant, that GPS monitoring is necessary to protect both the public safety and the victim, the device is installed before the release. Second, when the victim is informed and consents, she is equipped with a protection tool connected directly to the device on the offender's ankle. The court can define a roving stay-away zone that follows the victim. And just as important, the victim has the opportunity to choose to add that protection, which alerts her and serves as an immediate deterrent. This is not about forcing a system on someone. It is about giving a tool and a choice at the moment when they are most vulnerable. Victim protection should begin before release, not after another incident. And that brings us to HB 161. It addresses defendants alleged to have committed sex trafficking or trafficking of children for sexual purposes. It requires the court to consider criminal history and whether a defendant poses a threat to the victim or the community. I agree with that approach. But I would ask the committee to take one more step. Today, under Louisiana Criminal Code 320, specifically subsection I-2, Louisiana law already allows this level of protection in first-degree rape. When GPS is ordered, the victim may be given a receptor device. Louisiana has already made this policy decision. We already allow this level of victim protection only in first-degree rape cases. What I'm asking is simple. That same opportunity should be available for victims involving human trafficking, violations of protective order, and aggravated violent offenses when GPS is already ordered. Because the risk in those are not theoretical, it is real and it's ongoing. When in the Christian King case, because of the victim protection, law enforcement and fire department were able to get on scene in record time. We were able to get the offender in custody quickly and save the victim's home. That is the difference between reacting after the fact and having a system in place that can respond in real time. This amendment ensures the victim is given the option of added protection. It is not a mandate. It does not take away the discretion of the judge. It allows the victim to say, yes, I want this protection. Thank you for your time.
Thank you, Ms. Dennis. I'd welcome you, should the bill pass out of the House, I welcome you to work with the author on the Senate side, but certainly any amendment on the fly like that, not capable of doing right now.
It's more about information.
Thank you so much.
Thank you.
We have red cards.